Hi, I'm Donna Wright, Communications Manager of the VIP Institute for Procurement, and I'd like to welcome and thank you for joining us for the VIP webinar, Center for Verification and Evaluation Protest and Appeal. This webinar was developed with the goal to help veteran businesses accelerate your growth in the federal marketplace. And that's what VIP is all about, accelerating the success of veteran-owned small business government contractors, and it's working. On average, companies grow 54% 1 year after graduation from the VIP program. VIP offers different curriculums to give veteran-owned small businesses the tools they need to win government contracts. Programs are held in the Washington, D.C. area, just 11 miles from the White House. Participants receive hands-on, market-based instruction that help establish best business practices for federal government contracting, and the program is offered at no cost. We currently offer VIP Grow, our core curriculum, VIP Start for veteran-owned small businesses looking to become procurement ready, and VIP expanded its curriculum and now offers VIP International to accelerate veteran small business success in the global marketplace. This webinar series is made possible thanks to the support of SBA. Its goal is to provide resources to the 20 veteran business outreach centers located throughout the country that support veteran-owned government contractors with entrepreneurial development services such as business training, counseling, and mentoring. And it's also a resource for VIP alumni to ensure their continued success in the federal marketplace. This slide and audio from this webinar will be made possible on the VIP website at www.nationalvip.org. It is now my pleasure to introduce a leader in his field, Judge Christopher Holleman, Administrative Judge, Office of Hearings and Appeal. In 1995, Christopher Holleman was appointed as administrative judge in the Small Business Administration's Office of Hearings and Appeals. He adjudicates the full range of cases before OHA, which include size appeals, NAICS code appeals, service-disabled veteran-owned small business concern appeals, and economically disadvantaged women-owned small business concern appeals. Judge Holleman also serves as a mediator, handling employee grievances and EEO complaints. Before joining OHA, he served in SBA's Boston's office as New Hampshire District Counsel, and in SBA's Office of General Counsel. He has over 30 years of experience at SBA. Please join me in welcoming and thanking Judge Holleman for his service and thoughtful leadership. Without further ado, I give you Judge Holleman.
Donna, thank you so much. Far too warm an introduction for me. Hi, I'm Christopher Holleman, as Donna said, an administrative judge at SBA's Office of Hearings and Appeals. And I'm here to talk about the new Center for Verification and Evaluation Protests and Appeals at SBA OHA. Now, at the end of 2016, Congress passed the National Defense Authorization Act for fiscal year 2017. And in that, they gave jurisdiction over protests and appeals from the Department of Veterans Affairs Center for Verification and Eligibility to the Small Business Administration Office of Hearings and Appeals. On March 30th, we published the regulations under which we'll be handling these. The regulations go into effect on October 1st. And I'm here today to walk you through the process, what those regulations say, so you know what the procedures will be for handling these protests and appeals starting October 1st. Veteran-owned small business and service-disabled veteran-owned small business set-asides. Department of Veterans Affairs has certain contracts set aside for this kind of firm. However, when these awards are made, sometimes there's a question as to whether the firm that received the award is actually eligible. So who can file a protest under the Center for Verification and Evaluation of the eligibility of one of these firms? Well, the Secretary of the VA can, the contracting officer can, or an unsuccessful small business concern who bid on the solicitation and did not win, one of the other offerors. All of these parties could file a protest if a VOSB or an SDVOSB is awarded a VA procurement. What can be protested? The contracting officer or an unsuccessful offeror can make a challenge to claim that the awardee cannot provide evidence that meets the definition of a veteran, service-disabled veteran, or service-disabled veteran with a permanent severe disability. This would be the individual upon whom the firm's claim of eligibility is based. Also, the protester may protest that the business concern is not at least 51% owned and controlled by a veteran. When can the protest be filed? If it relates to a VA procurement, the contracting officer can file a protest at any time during the life of the contract. An unsuccessful offeror, however, can only file a CVE protest within please excuse me, I had to sneeze. An unsuccessful offeror can only file a CVE protest within 5 business days after being notified of the awardee's identity. This is because the procurement process is going forward and we have to strike a balance between parties' ability to protest and the needs of the procurement to go forward. Saturdays, Sundays, and federal holidays don't count as business days. If the protest is not received within 5 business days, we'll dismiss the protest. For example, if on Monday an unsuccessful offeror is notified of the awardee's identity, the time period begins Monday, so the first day to count is Tuesday. Wednesday, Thursday, Friday are the 3rd and 4th days. Since the 5th day would be Saturday, the time period would roll over to the next business day, which is Monday, unless Monday's a federal holiday, in which case the deadline would be Tuesday. Where do you file the protest? You file the protest with the contracting officer, either in person, U.S. mail, or by email. But even if you use U.S. mail, you have to be sure it arrives there within 5 business days. The contracting officer then forwards that protest to us at SBA's Office of Hearings and Appeals. What must be included in a CVE protest? It must be in writing and contain the solicitation or contract number and the specific allegation, together with credible evidence that the protested concern does not meet the eligibility requirements for inclusion in the database. It's got to be specific. It can't be stuff just they're not eligible. You have to say why and produce whatever evidence you have to support that contention. What must include any information you deem necessary for the judge to consider. The protesters should put forward any information they have on the case at this time. All of the evidence they have put forward now. And finally, name, address, telephone number, and email address of the protester, and if they're acting through an attorney, of their attorney. Now, protective orders. This allows counsel for a business concern to review the confidential business information of a protested business as it relates to a specific litigation. We're going to receive the file on this company from the VA. If you're protesters counsel, you have the ability to review it under a protective order. You have to request that within 5 days unless good cause is shown when filing your protest. Procedures are laid out in our regulations. We will not issue a protective order to allow non-attorneys to review the case file. We have certain requirements we put on counsel that operate under protective orders. They have to agree not to pass the protected information on to anyone, including their client. They have to establish they're not involved in their client's competitive decision-making. It has to be outside counsel. If these terms are violated, that could result in sanctions against the attorney. I have, for instance, sanctioned an attorney by debarring them from practicing before OHA for a year when a protective order was violated. Filing and service requirements. All the parties, including the protested concern, must file a certificate of service with all pleadings and filings. That is a document signed by the person filing the pleading, attesting they've sent a copy of the pleading to all the parties listed and identifying the parties by name and address. When you're filing with OHA, you can submit on through our upload e-filing system at sba.gov/OHA or by email at ohafilings@sba.gov. And at our website, we have a template, an example of a certificate of service, so you can see what we mean. What happens when the protest reaches us? We issue a notice and order notifying all parties that we have received the protest and establishing a due date for responses, usually 15 days. You could supplement your protest within this 15-day time frame. For instance, if an attorney has reviewed the case file under a protective order, they could file a supplemental appeal based upon the information they've seen. Also, in this time, this gives the protester the opportunity to respond. After the date for responses is passed, the record closes, and we will not allow further pleadings unless there is good cause shown. When will I dismiss a protest? I'll dismiss the protest if I determine it's premature, filed before the allowable period, say it was filed before contract award, if it's untimely, if it's filed late, if it's not specific, if it doesn't contain specific allegations, or if it's based on allegations that are not protestable. In all these cases, we'll simply dismiss the protest, notifying all parties. Who can respond? Well, the protested business concern, of course, they get to respond and maintain that they are eligible. Also, the director of CVE or the contracting officer and any of the other offerors on the procurement would all have the opportunity to respond to the protest. It has to be filed by the date specified by the administrative judge in that notice and order. And if a party wishes to reply to a response, the administrative judge must approve it first. We don't want an endless string of pleadings, which in my experience become progressively less enlightening. So it's usually a two-step dance. The petition itself arguing that the protest and a response to the protest. The administrative judge's decision will be based on the case file and the information provided by the parties, although we will reserve the right to request further information if necessary. How does the judge decide a case? We give greater weight to specific, signed, factual evidence over unsupported allegations and opinions, and we base a decision on the preponderance of the evidence. Can the contracting officer award a contract after the protest is filed? No. The contracting officer must hold off on awarding the contract before the administrative judge issues a decision, unless the contracting officer determines that award is necessary to protect the public interest. If so, they've got to notify us of that determination. What happens when the protested concern is found to be ineligible? The director must immediately remove the concern from the database. Any awarded contract is deemed void ab initio, invalid from the outset, and the business must not submit an offer in a future VA procurement until it's readmitted into the database. Can one of our decisions be reconsidered? Yes. You can file a petition for reconsideration with us within 20 business days of receiving our decision. That petition must show that the administrative judge made a clear error of law or fact in the initial decision. After that, what we have is a final agency decision by SBA. Next, appeals. These are cases where someone has either applied to get into the CVE and has been denied, or they've been canceled out of the CVE by the VA. They can file an appeal with us challenging that decision. A business concern may only file an appeal if the decision is not based on the failure to meet any veteran or service-disabled veteran eligibility criteria. We won't question the VA's determination on something like that. Ownership and control of the business concern will be the only two issues we consider. Yet a business concern may file an appeal with us within 10 business days of receiving the CVE denial or cancellation. OHA will dismiss an appeal filed more than 10 days after the denial or cancellation. Late is late. What must be included in a CVE appeal? A copy of the denial or cancellation and the date it was received, an explanation, including any pertinent information the administrative judge should consider on why this cancellation or denial was made in error. If you're the appellant, this is your chance to make your case. Put all your evidence in here, any argument you have here at this time. And of course, include the contact information for the appellant or their attorney. Who does the appellant have to serve with the appeal? Once again, you've got to file a certificate of service, that document signed by the person filing the pleading, attesting they've sent a copy to all the parties listed and identifying the parties by name and address. We have a sample, again, on our website. When filing with us, again, you can submit either a submission upload e-filing at sba.gov/OHA or by email at ohafilings@sba.gov. All the CVE appeals must be served upon the Director of CVE and Veterans Affairs Council at CVE Appeals Service at sba.gov. How does a case file reach us? The Director of CVE must provide us with the entire case file. What happens after the appeal reaches us? We issue a notice and order notifying all parties we've received the appeal, and we establish a due date for responses, again, usually 15 days. Who can respond? The Director of VA or VA Counsel or a designee may file a response to the appeal by the date specified in the order. If the Director of CV wishes to file a response, they have to serve it upon the appellant and any other individual identified in the certificate of service. If the Director of CVE files a response, the appellant may file a motion seeking to reply the response and attach the reply. But the administrative judge will ultimately decide whether that reply is allowed. A standard of review, whether the denial or cancellation was based on a clear error of fact or law, and the burden is upon the appellant to show by a preponderance of the evidence that an error has occurred. We don't have new evidence, no discovery, no oral hearings. We won't allow evidence beyond the case file unless the appellant has shown good cause. What criteria will the judge use to make a decision? The administrative judge decision will be based on the case file, the information provided by the parties, and also reserving the right to request further information. We will give greater weight to specific signed factual evidence over unsupported allegations and opinions. We'll also be able to consider issues not raised in the pleading or the denial or cancellation letter if those issues arise in the course of our considering the case. Our decision is final. It's a final agency decision, and if we dismiss or deny the appeal, the Director of CVE's determination remains in effect. If we reverse the denial or cancellation, then the Director of CVE must reinstate or include the appellant in the database. Yes, the decision can be reconsidered. A party can file a petition for reconsideration within 20 calendar days of having received the initial OHA decision. That petition must show that we made a clear error of fact or law in our initial decision. Finally, here are the cites to the rules. I thank everyone for being present and listening, and I'm prepared for questions. Okay, one question. James Payne, are you aware that CVE is sending out notification to SDVOSB certified companies that need to do their renewal within 120 days when all renewal websites are on hold and have been hold for months? I have less than 60 days to expiration and may not have time to get renewed. I asked the renewal office and they told me to call back in 30 days. At present, CVE is not offering any extensions, and if your CVE EV expires, you have to start your certification process all over again. I'm not aware of that. That at the moment, it's not under our jurisdiction yet because we start October 1st. It does seem to me to sound like a problem, and I'm sorry, I don't have an answer for that. But I would say to have you can I help? And then this Mr. Paynes has his number, and at the moment I cannot help with that. I would suggest perhaps have you tried reaching Mr. Lenny or Ms. Torres at VA to raise that issue? I mean, Tom Laney or Beth Torres at VA would be the persons to deal with that. Um,
Okay.
and that's all I can say at that at the moment. Um, we are a franchise and we believe we meet the qualifications of day-to-day with Kroll. We applied for certification and revised to withdraw. Do you envision that the CVE will consider a site visit to consider, or is this going to be no with no way of showing what actually happens on site? My guess is that these will be mostly done on paper. I haven't had a direct experience with the CVE process yet. Um, you gave them documentation. If they just advised you to leave uh, without giving you any reason why you should withdraw your certification, that seems to me to be maybe less than helpful. I think one of the questions is who's controlling. I see you're a franchise. You might look at your franchise agreement. Does your franchise agreement leave you with the right to profit or the risk of loss on your own, based on your own efforts? How much control does the franchising company have over you? I think those are questions to consider. Question is who's in control? You have to be able to establish that you're really in control.
And anyone else? We have any other questions?
I have not contacted. If someone could forward their contact information, that would be helpful.
Mr. Payne, I'll be glad to forward the Tom Lenny's contact information to you at the conclusion. Or Ms. Torres,
Ms.
and
Torres.
Ms. Torres as well. Yes, we'll provide that information.
Further questions? Brickbats? I'm sorry, I'm not familiar with Vector. Further questions? Anybody? Oh, when does CVE transition to fall under SBA? The CVE will not be transitioning to fall under us. VA will still be running it. What will happen is on October 1st, SBA OHA will be handling the protests and appeals in the manner I've just laid out. But the VA will still be running it. They'll still have the files. When there's a protest or appeal, they'll have to pack up that file and send it over to us at SBA OHA. But VA will still be running it.
Any other questions for Judge Holleman while we still have him sitting down?
Well, thanks.
The slides will be available as well as the recording of this webinar on our website at nationalvip.org. And I believe everyone that's a participant will also receive a copy of the email, a copy of the recording to your email. All right, if there's no more questions, last call for questions. All right, well, thank you, Judge Holleman, for your excellent presentation on the Center for Verification and Evaluation Protest and Appeals. And thank you to our participants for attending the VIP webinar and to SBA for making this webinar possible. Again, we hope you found the information presented to you to be helpful. I would like to ask that you take a moment to complete the very short survey that will be sent to you immediately following the webinar. Your feedback is really important to us. Thank you, and we wish you all continued success in 2018. Have a great day.
Man, you're welcome.